What happens when there's a conflict between the declaration and bylaws contained within the offering plan, this guy, or if there's a different declaration that's recorded in the county clerk's office? Which one controls? That's the question. Hi, and welcome to episode 1, numero uno, of the Lasser, New York Real Estate Podcast. I'm today's host, Stephen Lasser, and I'm the managing partner of Lasser Law Group. We're a law firm with offices located in Manhattan, Westchester, and Long Island, and we serve the 5 boroughs, Westchester, the Hudson Valley, and Long Island. And we are currently broadcasting this video on YouTube and with audio on iTunes. And if you're watching on YouTube, please give us a thumbs up. If you learned something or you like the content, please click subscribe to receive notifications when we create and post new content. Today I'm going to be discussing the governing documents for condominiums and homeowners associations. So if you are purchasing a condominium or homeowners association, you might receive, or you should receive, or your attorney should receive, an offering plan. This is what an offering plan looks like. It's a sales disclosure document. You can see ours is marked up here with a lot of important paragraphs and pages marked up. And this is a sales disclosure document, and it's produced by it's called the sponsor. The sponsor is the developer who basically buys the parcel and then divides it up into separate condominium units or homeowners association townhomes, and then sells them to the public. They have to file the offering plan with the Attorney General and get approval from the Attorney General, and then they're allowed to sell property to the public. Within the offering plan, you'll see there's a table of contents. I'm going to show it briefly up on the screen. And it has, look at this, maybe we'll get a better shot. But anyway, it has things such as the description of the property, the terms of the sale if you're going to purchase the unit, the identity of the seller sponsor, tax opinion letters, and a whole bunch of other disclosure items that would help you make an informed decision in purchasing into this community. Another document contained within the offering plan is the Declaration of Bylaws. And the Declaration of Bylaws are the corporate governance documents for homeowners associations and condominiums. And they would set forth things such as voting rights as an owner, repair issues, if you wanted to replace something within or outside your unit, who's responsible, the community or the individual owner. And it also has the allocation of expenses, meaning how much are you going to pay each month towards the overall expenses of the community, and that's based on a percentage, although there's some variations for commercial unit owners, and it's part of what I'm going to be discussing today. The offering plan has a copy of the declaration contained within it, but separate and apart from that, the sponsor has to file a copy of the declaration, which is contained within the offering plan, with the county clerk. Sometimes, however, the copy of the declaration or the version of the declaration that's filed with the county clerk is different from the version of the declaration that's contained within the offering plan. So when you actually purchase a unit in a HOA or a condominium, you get a deed. And the deed is the legal instrument that passes ownership to you. And in addition to passing the ownership rights from the seller to you, it also creates a contract between the purchaser and the community. And when you take a deed, when you receive a deed, that's also recorded in it, and it references the recorded declaration. So, question that came up recently with my firm, or not that recently, but a few years ago, but the conclusion happened recently was what happens when there's a conflict between the declaration and bylaws contained within the offering plan, this guy, or if there's a different declaration that's recorded in the county clerk's office. Which one controls? That's the question that I'll be discussing today. So surprisingly, there's no statute directly on point. There's some statutes that talk about the declaration and recording it, but there wasn't any case law or statute that squarely deals with this issue. So the case where my firm was hired that addressed this issue happened like this. In 2017, there was a condominium building in Manhattan. It had a retail space, and there was a commercial unit owner. So in other words, someone owned, there were unit owners who own apartments within the building, and then the ground floor, there was a commercial unit owner. And the commercial unit owner had as a tenant, had a small restaurant chain as their tenant. So presumably they were making money. In other words, they were collecting common charges, and those common charges, they were collecting rent from the tenant, and the tenant's rent presumably exceeded the common charges. So this person, or the unit owner, commercial unit owner, was presumably making money. They had a plumbing issue, or the restaurant tenant had a plumbing issue. The condominium ended up fixing it. The commercial unit owner didn't want to pay for the plumbing expenses. Then subsequently, the common charges for the entire building were increased, and the commercial unit owner decided that he wasn't going to pay the common charge increase, and then he stopped paying common charges altogether. So this happened around 2016, 2017. My firm was retained to collect the common charges because the commercial unit owner stopped paying the common charges. So when we were retained, we looked at the building's governing documents, the offering plan, and the declaration, and it turned out that the formula for calculating the common charges in the offering plan was the common charges for the commercial unit owner was 13%. However, in the recorded declaration, we noticed that the common charges were supposed to be calculated. I said that backwards. The common charges in the offering plan were, for the commercial unit owner, were 5%, and the common charges for the commercial unit owner in the recorded declaration were 13%. So we advised our client that we thought that they were actually billing the commercial unit owner incorrectly, and that they'd been underbilling the commercial unit owner by a magnitude of 50% for a significant period of time. So we tried to mediate a resolution with the commercial unit owner, and unfortunately we weren't able to reach a resolution. We actually offered to just collect common charges at the lower rate of 5% retroactively in exchange for the unit owner paying the correct amount, or what we believe to be the correct amount of 13% going forward, and we would waive the difference on the retroactive. However, I could understand the commercial unit owner's perspective. They said, look, you've been billing us the wrong amount for 20 years. You're not going to double my common charges. And litigation ensued. And that was, that started back in 2017. In 2020, we finally got a decision from the court. And the answer to the question is the recorded declaration and bylaws control. Consequently, the commercial unit owner has to pay 13% retroactively and prospectively, and we're at that phase of the case now. So what's the takeaway? The takeaway is you should know that your governing documents in an HOA and condominium are the declaration and bylaws, and whether you're considering purchasing a condominium unit or a home or a HOA home, or if you're living in one currently, or you're serving on a board there, or if you're managing one of these properties, you should be aware that it's the recorded declaration that controls, and not the declaration contained within the offering plan. So thank you for listening and watching, and please remember to subscribe and remember to make every day great. Thank you. Bye.